Hi guys, what's up? So I welcome you all again to this another new video. So yes, how you guys doing? I hope you are absolutely fine because I am fine. So you must be fine. So yes, let's begin with the video. Actually, yesterday I put a title on the video on this series of video, and because I confined my previous video on a particular topic, and I discussed about that topic only in the whole video, so it was looking quite structured, and therefore I gave a title to that video. So now onwards, I am thinking to go with the same, like I am going with that pattern only to put a title and then go on with the uh, scheme of the title only. So yes, let's talk about today. So today, yeah, so today I actually learned many things, like it was quite conceptual learning that I gained today. One first and foremost thing which I found is of utmost importance I would want to share with you is that when you are filing the bill so the background of this all observation and learning is that of the courtroom only, because I am interning and I have to speak, give you knowledge about something which is helpful if you are that particular audience. So I am giving a speech only on that thing only, like for law people only. So yes, today I observed a very good thing, very significant thing that everyone should keep in mind while arguing. So yes, while actually when you file a bail petition for your client, so you should not sorry, so you should not just give evidences and the you should not give evidences and arguments on the whole case. Like you should confine yourself only for the bail. So first understand the basic principle of the petition. For example, bail petition. If you want bail for a client, then your arguments should make logic and they should be coherent with your title. When you are applying for the bail, the first and foremost thing is that why you want him to be out of custody, like why you want him to live in the open society, because there are many grounds that you can put, and what I observed that I would like to share with you. First, if my client will be on out on bail, then he will not tamper any evidence, and this tampering of evidence is directly related to the case. So if the uh, main witnesses are examined, sorry, material witnesses are examined, and all the material evidences are placed on record of the trial court, then there are very less chance of tampering the evidence, or less to no chance of tampering the evidence. So court is not reluctant to give the bail. This is the first and foremost thing that you should highlight in your application. And if the material property or the case property or the proceeding of the offense are already recovered, then why you want the custody of my client? Just to infringe his liberty? If yes, then take him, infringe his right. I will file petition for habeas corpus. This is actually very deep, like, but it is not the case here. So yes, these are the things that you should confine on yourself on applying for the bail, on the arguing for on the bail petition. You should not just showing your evidences and maintaining your argument on that. And so this is for the bail. And if you're filing the quashing petition, Causing of an FIR, there are actually two things which I have already discussed in my previous series of videos. So if the causing petition is filed, it is filed basically on two grounds. Like if you have either of the ground, then you are eligible to file. First, for example, on merits, and second, on the settlement between the parties. So on merits, if you are going on merits, then it is a very difficult job to get order in your favor, because it requires a huge lot of skills to frame your arguments and to convince the judge, because on merits is quite next to impossible thing to prove in the court, because trial is going on in the lower court, and the judge is not ready to appreciate the evidence in the appellate court. Then how will you prove? So the basic principle or basic tenet to prove this type of cases, to extend the argument on these type of cases, is that you have to show the procedural irregularity or the patent defect in the procedure, which is continuing in the lower court. So if you are successful in proving that thing, then the grounds for the question of FIR is made out. Otherwise it is very difficult, and on the basis of this thing only, to showing the procedural infirmity, then only you will be able to secure uh, relief order in your favor for quashing of petition. Otherwise, if you are just showing evidences, just showing Katie now judgment on whatever law point you have, it doesn't matter. You have to stick on the procedural aspect. If it is something that is being ruled out, or it is a foul play on the part of the prosecution, then it is a good ground and you will get the coercing of FIR done. So yes, this is the basic knowledge. Firstly, I talk about the bill. Like if you are filing the bill, then you should frame your argument on the way that why you want that person to not in custody. So this is the main bottom line of that argument. And if you're filing for quashing petition, then you should show the procedural irregularity. Otherwise, there is no other ground for quashing of FIR on merits. So this is the two basic things, two significant thing that I would want to discuss with you in my video. So yes, that is it for today, I think, and I will meet you tomorrow on some new thing and some new aspect, new learning. Till then, tata, bye bye, take care. Thank you so much for watching. If you have come till here, then please drop a comment, like what are the things you like, or mainly the what are the improvements that you would want to see in the video. Thank you so much for watching. Tata, bye bye, take care.